The first General Warren Hastings caused the codification of Hindu law, and Cornwallis Code was another major contribution. Similarly, the Islamic law was also codified and adopted in courts. The Regulating Act of 1773 empowered the Crown to establish the Supreme Court of Judicature in Calcutta, and the Charter Act of 1774 expounded on the jurisdiction of the court. However, the Supreme Courts were not established at Bombay and Madras during the same period. The Supreme Courts were established in Madras and Bombay in the years 1801 and 1824 respectively. In 1793, Lord Cornwallis prepared a set of regulations popularly known as the Cornwallis Code, and it dealt with both criminal and civil justice. He reorganized civil courts, abolished court fees, and reformed the criminal courts. Lord Minto, after being appointed as the Governor General of Bengal in 1807, increased the powers and jurisdictions of the various courts. Lord Hastings, who became the Governor General in 1813, introduced many reforms in the civil and criminal judicature of the country. Efforts were taken to curb red tapeism in the administration of justice. He was succeeded by Lord Bentinck, who reorganized and consolidated the whole system of judicial administration in India. He abolished the provincial courts of appeal, and their functions were transferred to the district Diwani Adalats. Between 1834 and 1861, the King's Court and the Company's Court formed the dual system of courts with separate jurisdictions. The Indian High Courts Act of 1861 empowered the Crown to establish the High Courts of Judicature at Calcutta, Madras, and Bombay, and this led to the abolition of Supreme Courts. This was considered a landmark in the evolution of the High Courts in India. Later, the Government of India Act of 1935 effected considerable changes in the nature and jurisdiction of High Courts. Between independence and enforcement of the Constitution, 7 High Courts at Punjab, Assam, Orissa, Rajasthan, Travancore, Mysore, and Jammu and Kashmir were established. The other high courts were established later. The Constitution of India, after being enforced, recognized all the existing high courts and empowered the Parliament to establish high courts for all states or combined high courts for 2 or more states and union territories. The 42nd Constitutional Amendment Act 1976 brought in drastic changes in the jurisdiction of the high courts. Thus, in the very beginning, there were only 3 high courts of Calcutta, Madras, and Bombay. The acts and regulations prior to independence brought in remarkable changes in their organization and jurisdiction. With respect to the establishment of the Supreme Court of India, the Government of India Act 1935 is a landmark legislation. The act attempted to change the structure of the Indian government. There was a shift from a unitary to federal type of government, necessitating the feed of a federal court. Thus, the act made a specific provision in this regard, and the federal court was inaugurated in the year 1937. It consisted of a chief justice and 6 judges. In 1915, the Federal Court of India was succeeded by the Supreme Court of India. The Federal Court, in a short span of 12 years, left an indelible impact on the legal history of India. It was the first court with a national jurisdiction. It was from this Federal Court that its successor inherited the traditions of independence, integrity, and impartiality. Also, between 1726 and 1833, the role of the Privy Council requires special mention. It contributed so immensely to the judicial system in India, laying down the fundamental principles of Indian law that serves as a beacon to the Indian courts even today. The the Indian Independence Act of 1947 resulted in the transfer of political power, and this necessitated the establishment of a separate and independent judicial body. With this objective, the jurisdiction of the Federal Court was enlarged, and the abolition of the Privy Council Jurisdiction Act 1949 was passed, making the Federal Court the highest judicial body in the country. With the enforcement of the Constitution on 26 January 1950, Article 124 provided for the establishment of the Supreme Court of India. Thus, there has been a slow and steady evolution of the Indian judicial system, and it has proven to be better and wiser with time.